Adhikari, Managing Director, Governance Now. And it is my extreme proud privilege today to welcome none other than Shri Aryama Sundaram ji. Thank you so much, sir, for joining us.
Pleasure.
So my first question to you is, nowadays a lot is being said in the media about the human resource crunch in the Indian judiciary, which ultimately leads to delays in delivering justice. What steps would you suggest to ramp up the infrastructure of the Indian courts?
Look, the fact of the matter is that in India, the nature of our manner of expression of justice, various appellate forum which have been given statutorily, the tendency to have elaborately long arguments even for interlocutory matters. Cases are taking long to complete, far too long to be. So we have, on the one side, we have the existing cases which are taking far too long to be completed. So where is the question of touching the backlog of cases? Second, we have a shortage of judges in the country, which even with that shortage have been removed, even if all the courts were in full complement, I cannot see us clearing the complete backlog. It is not something which is practically possible, especially because cases which are more immediate, more relevant, more today, here and now, are coming up repeatedly. And the courts are forced to deal with those cases on a day-to-day basis. Now, if you just take, for example, the pandemic COVID, the number of cases which came out of that, those are not cases you could have said, all right, go back and stand in queue, and you come and wait your turn. So there are too many cases which we find today which require the here and now attention of the superior courts. So because of that, backlogs both in the Supreme Court and the High Court, even with a full complement, is most likely to keep occurring. And I don't see how we can get rid of that backlog, even if we run with a full complement. The point is, I think two things have to be done. Number one, the time taken in arguments by lawyers for the purpose of any case, any interim matters, anything, that has to be cut short completely. United States Supreme Court has a rule of 20 minutes or half an hour for each side. That's it. No more. Now, cases, even in the case of, where they were deciding on the presidency between Gore and Bush, each side was given only 30 minutes. See, so much of the litigation in the United States is done through written briefs. Now, one thing is written briefs too. The judges will then have to study those written briefs completely and be absolutely thorough. And in the half an hour, ask only those points which they want clarified. But in the half an hour, if you're going to start by explaining the case from the start, you can't finish in half an hour.
Absolutely.
So this is one. Second is, government must learn how not to appeal. You see, the government is what sets up all the tribunals. There are tribunals set up, manned by the government, selected between the judiciary and the executive. Now, if more than 70% of appeals against tribunals' orders are governments, more than 70% of pending appeals, 50% to 70% of pending appeals in India are the government on one side. So you see, you've got to understand one thing. Government litigation, government should learn that they should not become another litigant, just another litigant. I mean, a matter of, the tribunal decides in favor of a company and says 6 crores was wrongly taken. The government comes on appeal saying it's 6 crores involved. Of course, 6 crores is involved. But then if you keep doing that, how do you ever expect there not to be a backlog, leave alone clearing the backlog?
So naturally, I mean, there are some inherent issues which must be addressed.
Government has to look at it very strictly, and the courts also have to look at the timing that they will give a counsel to argue very strictly.
Absolutely. Now, coming to the point of ethics in the field, judiciary has always maintained that it is, independent of the executive. Now, when we see that, after retirement, certain important judicial posts affiliating to a party or taking some positions within the parliament or in the government, how far do we trust the fact that there is independence between the judiciary and the executive?
Look, independence of the judiciary is something which is vital, because if you don't have independence of the judiciary, you don't have democracy. So, sans separation of powers and independence of judiciary, there is no democracy. We have to rest assured and believe in the integrity of the judges. That merely because after they retire, they may head some tribunal or the other tribunal, ought not to be a ground to make them, deal with cases in any other manner than absolutely independently. I know many, many judges of the Supreme Court who have been so independent, judges of the High Court who have been so independent and who have decided independently, not concerned as to whether or not they're going to man a tribunal thereafter or not. So I think this goes to the, if judge's integrity is such that a judge cannot be influenced by anything, if that is so, the fact that he may or may not get a tribunal to head after his retirement would equally not be a factor to influence him in any way. There's no difference. There's no difference whether you're promised something here and now or whether you're promised something after retirement. In both cases, if that is going to make you decide one way or the other, then, well, you don't have that integrity as a judge at all.
True. Now, Sundaramji, if I may ask you regarding, there are cases these days regarding if there is an case of inability of the executive, and then there is charges of judicial activism. So do you agree that, judicial activism exists because there is an inability of executive to take appropriate right decisions?
Look, let's face one fact. There is a Lakshman Rekha, constitutional Lakshman Rekha, between the executive, legislature and the judiciary. The whole doctrine of separation of powers, like I said earlier, the whole independence of the judiciary from the executive, and equally the right of the executive and the legislature to enact laws, the right of the executive to decide policy. These ought not to be interfered by one or the other at all, except in the rarest of rare cases. Now, what we find here is that, yes, there is an accusation of judicial activism because there are too many public interest litigations that have been filed, many of which, I'm sorry to say, are very hardly private public interest, but they are very personal interest litigations. And I think too many of such litigations are being filed, which impinge on policy issues. And I believe the law is very clear on that. The law is very clear that the judiciary will not involve itself in policy issues unless it's the rarest of rare cases. That is, that policy must be one which violates a fundamental right. If it does not violate a fundamental right, as a rule, you do not interfere with policy because it is rather leave it to the elected men of the legislature or the experts in their field to decide on the policy than nominated or appointed people on the judiciary. It doesn't make the judiciary any wiser than the executive or the legislature. And I think that Lakshman Rekha should be maintained and to be crossed only if fundamental rights are affected.
Absolutely. Now, talking about the Indian judiciary being adaptive to the new normal way of functioning, do you believe that the Ecodes are able to facilitate the entire process of justice effectively, or was the physical appearance more effective according to you?
So far as that is concerned, I think these Ecodes are more than able to discharge their the functions which have been assigned to them. And like I said, it goes back to this. The difference between the E-court is that, yes, to that extent, there is no person-to-person eye contact. Very often, you cannot make out what is passing through a judge's mind. Very often, when you're urging a point, and you can see visually when you're in court that it's not appealing to the judge. A good counsel would say, all right, let me not waste the time of the court on that point. Let me go to my next. Now, in this over the computer, in this virtual hearing, you cannot make out any such thing. So very often, you go on and on and on pressing on something without noticing that, look, you've lost the court. The court is not with you. So to that extent, I think even the litigant is not fully satisfied with the e-courts and would rather have a physical court so he can actually physically see what is going on in court. But left to myself, I believe the e-courts is a great start. I believe that this kind of virtual hearing is absolutely excellent. I mean, senior counsels are being accused of liking it because we're able to appear in a number of cases in a number of courts. Whereas, otherwise, if we're in the Supreme Court, we cannot obviously go to the High Court or to the Madras High Court or Bombay High Court and do work in the Supreme Court that day, whereas now we can. So that criticism has been leveled against senior counsels. But I would say, so long as the superior judiciary are themselves prepared with the case before the case is taken up, I think that this virtual hearing is more than sufficient to dispense justice.
Absolutely. So having a pre-knowledge of the case would really help not
I
only
think that
in
is a must.
clearing the
That is a
backlog.
must.
Yes, not only in clearing the backlog, as you mentioned, as an answer to my first question, but also to the fact that it would facilitate better Ecodes.
Absolutely.
According to you, yes.
Absolutely.
Now, so you're a renowned senior lawyer, counsel. You have handled high-profile cases. The media has spotlight on those. How do you deal with client expectation pressures that come along with such cases? I mean, clients expect a lot.
Look, the fact of the matter is that everyone who goes to court hopes that he will win. The hope of winning becomes so strong, the hope, that it then transforms itself into a belief. And that belief becomes such a strong belief, it transforms itself into an expectation. The fact of the matter is there are two sides to every argument. There are two sides to every coin. There are two sides which are involved in any litigation. And both can't win. It's going to be one or the other. So while both sides may expect victory, counsel usually would point out to his clients that, look, these are the holes in your case. This is where you may lose your case. The best thing to do would be to take an approach, which may even be conciliatory in many ways, to try to sort it out. Which may you may even suggest settlement in many cases for that reason. So I believe that yes, expectations are there, and yes, expectations are belied, but then that is litigation. And I think any corporate house, especially a large litigant, does realize when he starts a litigation that there's every chance that he will fail in it, and finally, and should be ready for it.
Absolutely. Now, we live in the age of social media, and many a times in the social media age, lawyers are trolled for taking up cases where public sympathy is least.
Oh. Sorry, excuse me. Yeah. There's some disturbance. I was just trying to get that clear.
No worries. So I was coming back to my question that, in the times of social media, we live in a social media age, and lawyers are trolled big time if they are associated with a case where public sympathy is least. How does a senior counsel of your stature deal with such trolling, if at all it happens?
Well, you can't expect it not to happen in certain cases. Look, let's take cases like your temple entry. Now, in Kerala, Sabrimala case, we have many people on one side, many on another.
True.
So whether you like it, and it becomes a very emotional issue. Cases like the triple talaq would be an emotional issue. There are many cases which are emotional issues. So when they're emotional issues, one side or the other tends to do that. I remember when I was appearing the Jallikattu case, which was became such a social issue in Tamil Nadu, whereas I was really arguing to say that Jallikattu should be banned. I expected it, and it did happen, that my appearing in that matter was very disliked by many people in Tamil Nadu, who felt I should not be appearing in the matter, who did troll me, who did all that. But the fact of the matter is, when you take up a case which is emotional in results in many cases, many occasions, you should expect, and it should not worry you at all. In my case, it doesn't worry me at all because I take up a case to do that case. Of course, if I so strongly believed against something, then I wouldn't do the case at all.
True. Yes.
I wouldn't at all.
Absolutely. Now, do you believe that the media trial, which happens these days, knows no bounds and pronounces its verdict much before the case is actually heard by the honorable courts?
This is a danger, and I'll tell you where the danger lies, actually. There is a doctrine of what's known as sub judice, that when a matter is sub judice, it ought not to be commented on.
True.
You can comment on it, reporting what has taken place. But you cannot give your opinion on the result or your opinion on those proceedings.
True.
Whereas nowadays, I find all the time on the media, while a case is going on, a hearing has taken place today, and then it's going to continue. Then you have large debates where people are discussing what is the right and what is the wrong, which way the court should decide, which way it should not. And I believe, coming under the doctrine of sub judice, technically, this would not be correct at all and has to be put a stop to. I myself am often on the media on various issues. But when I'm on the media on various issues, I always make it a point that when a matter is sub judice, I tell them, look, I cannot comment on it. I will comment on it once the judgment is passed or an order is passed. I'm happy to comment on the judgment or the order. I'm happy to comment on an issue before the court starts a hearing on it. Once it goes into court and there's a hearing on it, in the course of the hearing, while the hearing is going on, giving an opinion as to what should be the likely outcome of it, I think is certainly wrong. The media should not encourage it at all.
Absolutely. Now, Sundaramji, that in the light of recent high-profile matter, involving a Bollywood actress and her husband, do you feel that celebrities, when caught in a legal soup, are more vulnerable to harsh judgments vis-a-vis a common man who would probably gain more sympathy from the courts?
Well, let's understand one thing. Criticism is often that celebrities get the raw end of the stick. The fact of the matter is, a celebrity also gets tremendous laudings, great advantages. Society gives him tremendous advantage. Now, the celebrity gets advantages both by the worship of the people, by his own privileges granted to him. He goes in somewhere, he's recognized, he's taken in, he very rarely stands in a line anywhere. All these things are benefits. The downfall of it is that if you go wrong anywhere, then the brickbats come at you much harder than the brickbats would at someone who's an unknown quantity. A person who's not a celebrity at all, who's not a media figure at all, who's nowhere there. If something happens and he runs over somebody, let's say in a car, it may not be commented on to the extent that it would be if it's a celebrity who did it. Because the celebrity is more of the public eye. So it's a very, very natural thing. As to whether the courts would be a bit unfair in the judgment for such people vis-a-vis others who are not celebrities. Look, the fact of the matter is, once a person's a celebrity, the media attention is on the case. We like it or not, media attention, everyone's attention is on the case. The court has a duty then to show that law will be subserved. Whereas in some other case, the court may have turned around and said, look, yes, I agree, there's been a transgression, but I think there were enough reasons for it, so I'll let this person go off leniently. Or he's a poor man who has to feed his family, I'll let him go leniently. These are factors which may come up in sentencing, in giving him a minimum sentence rather than a maximum sentence. Whereas in a celebrity, people are looking to see what the court is doing. And in many ways, it is also the faith in the judiciary which demands the judiciary to lay down the law with an iron hand in such cases. Absolutely. And according to me, a celebrity who is taking all those privileges, be ready when he does something wrong to take the punishment which comes with it. It is you can't claim the privilege of not being punished for any transgression on your part.
Absolutely. So if a celebrity enjoys the perks and privileges, then naturally
they enjoy the brickbats also when they're
two sides of the same coin. Yes. Now, my last question, Sundaramji. It is often said, that the law profession is recession-proof. Do you agree? Or
sorry, I missed the question.
Yes, the question is, sir, that it is often said that the law profession is recession-proof. Do you agree, or has the pandemic made people realize something different?
I think let's just cut it for a minute. My connection is a bit bad. Can we just repeat it? Your question?
Yes.
Sorry.
So it is often said. Yeah. Can you hear me now, sir?
Yeah, just about. Yes, tell me.
It is often said that the law profession is recession-proof. Is it true, or has the pandemic made people realize something else?
Something other than what? The law profession?
Yes. Is it recession-proof, or is it not?
Look, that's a double-edged sword. Because let me tell you, of course, in the pandemic, when the courts were not really sitting to hear regular cases, really hearing cases only of public interest, matters involving the pandemic, naturally the litigation and commercial matters was at almost zero. So commercial litigation came down. The kinds of litigation which normally are the litigations which there's a lot of, which are very expensive litigation, did not take place. Now, even in the public interest matters which the courts did hear, most councils, when approached in a matter like that, when, for example, the migrant workers and their stance, and a council is asked whether he would argue that matter, obviously he's going to do it pro bono. He's not going to be taking a fee for that. So yes, at the pandemic at its worst, well, there was no, the courts did not really deal with any commercial matters, and the courts only dealt with urgent matters of public importance. And to that extent, yes, I think all lawyers at that time had to sit back. Well, I looked at it as a forced sabbatical, where I could do a lot of my reading and do other things which I enjoy doing. But,
absolutely. True. With that, thank you so much, Shri Aryama Sundaram ji, for joining us on this episode of Visionary Talks by Governance Now. And thank you so much, ladies and gentlemen, for also joining us. It was a complete pleasure and honor to have you, sir, today with us. Thank you so much.
Thank you very much. Thank you.